Welcome back. Now that we've covered the three main types of primary sources, cases, statutes, and regulations, we're ready to move on to secondary sources. Let's start by talking about what secondary sources aren't. Secondary sources are not the law. Now, what does this mean? For practical purposes, it means that 90% of the time you are not going to cite a secondary source as authority for your position. So you would not, for example, cite a legal encyclopedia to a judge as authority for the position you're taking in court. You're also unlikely to cite it as authority to the opponent in your case. Well, what about the other 10% of the time? Well, that actually might be an exaggeration. Let's make it 5% of the time. There are times when a secondary source is so well respected and highly thought of that you might be able to cite it not because it's an authority, but because it might persuade the judge or the other side. For example, there are some treatises that are highly valued, and if you cite one when there is nothing else that you can cite for authority, the judge might be persuaded to follow the opinion of that treatise. Or, for example, there are some law review articles written by people who are so highly respected. For example, Dean Edwin Shermaninsky at the University of California, Berkeley School of Law, or Lawrence Tribe, who is now retired as a professor at Harvard Law School. These people were so highly respected by many judges that they might be persuaded by something they wrote, but they also might not be persuaded by them. So citing a secondary source is not something that the judge or the other party has to be persuaded by, but they might hold them in such high regard that they might be persuaded by them. If secondary sources aren't the law, then what are they? Well, they talk about the law. Secondary sources explain it to you. They comment on the law. They provide analysis of the law. They can be very general or they can be very specific. So, for example, burglary at common law was defined as the breaking and entering the dwelling house of another at night with intent to commit a felony therein. So you could have a secondary source that discusses all aspects of burglary. Or you could have one that is so detailed it asks, when does night begin and end? Is it at a certain time? Is it when the sun goes down? Is it when the street lights come on? And so forth. So secondary sources can be very general and give you a broad overview of a topic, or they can be very specific down to a particular point of law that you're interested in. Now, I know what you're thinking. If secondary sources aren't the law and if they don't provide me with authority, then what good are they? Well, they're good because they do explain the law to you. Many people come in here with just a vague idea of what it is they're interested in, and if we can sit them down in front of a secondary source on the topic, they can read it and start to understand their legal issue, and from there do their research. Another reason to use secondary sources is because they will provide you with citations to primary sources. For example, I enter letters from the prisoners in the county jail system, and they often want me to send them cases on this or the statute on that, and I can't do that. I'm not allowed to do legal research for people. But what I can do is send them a secondary source on the topic they've named. The secondary source cites cases and statutes, and then they can send me the citation to the statute or the case that they want, and I can send them that. So if you don't understand the topic, you can study it. You can find sources you can find citations to the primary sources, and you can use those citations then to go find the actual authority. These are the types of secondary sources I'll be covering in the next few videos. There'll be one video on legal encyclopedias, one on American law reports, probably one or two on treatises and practice guides, one on form books, one on periodicals, and one on self-help books. Which secondary source should you use? Well, that's going to depend on a number of factors, but mostly on your personal preference and on what you hope to accomplish. I like to start with several of these depending on what I want to do. Unlike a lot of law librarians, I actually like law review articles as a good place to start, especially if I'm seeking to understand the historical development of the law on a particular point. But that's probably not what you're here to do. You're more likely going to want to start with a treatise or something like a legal encyclopedia. With experience, you'll find out what you like to start with.